Hello everyone, my name is Saumya. I welcome you all to Kalam Academy. I will be starting with the topic of writs, and in this video I will be discussing the writ of habeas corpus. Now this is a question based on our discussion. You may try to attempt this question based on the concept of habeas corpus. Now before we start with this, we have to understand what a writ is. Now writ is an order. Okay. It is an order which is issued by Supreme Court or High Court to uphold the individual's fundamental rights. Okay. Supreme Court issues the writs under Article 32 and High Court issue writs under Article 226. So they are issued, the writs are the orders which are issued by the courts to another person. Either they will issue the writ to a person or a authority. Okay, and they will require that person or authority to act or refrain from acting in a specific manner, either to act or to refrain from acting, depends on what the case is. Okay, so this writ can issue this writ can include either orders or warrants or directions. Okay, the courts can ask the person or the authority to either act on some kind of a matter or to refrain from acting from that matter, depending on what the case is. Now let's begin with the concept of habeas corpus. Now habeas corpus is a Latin phrase. It is a Latin term that literally means to have the body of. That means to bring or present the body, the person, before the court. Okay, so this is a writ which is issued by the court to a person who has detained another person to produce the body of that person before it. Now the court, the Supreme Court and the High Court will issue the writ to a person or an authority who has detained another person, and those courts will ask the person or the authority to bring that person before the court. Now why this is done so? Now this is done because this is not to penalize the perpetrator, the person who has done a crime, but it is to liberate that individual who has been unlawfully detained without any legality. If a person is detained, then by issuing the writ, the Supreme Court upholds the fundamental rights of that individual. So the basic objective is that the writ of habeas corpus is a judicial procedure that will serve as a corrective remedy for someone who has been unlawfully detained, unlawfully jailed. Okay, so now why we are doing this? This is done to relieve a person who has been wrongfully detained. Now, the court will consider the reason for the detention, why the person has been detained, and it will consider that whether that detention is legal or not. Now, if that detention is found to be illegal, then that detainee will be released, and as a result, the writ protects the individual liberty from arbitrary detention, which is based on illegality. Okay, so this writ is crucial since it defines a person's right to freedom and personal liberty. Now, under Article 22, the person who is arrested has to be brought before the magistrate within the 24 hours of his arrest. And if this is not done so, then that arrested person is said to be released. Now, the writ of habeas corpus can be issued against both the public authorities and the private individuals. Okay. Now, who can file the writ of habeas corpus? Who can file? The person who has been detained, the detainee, okay, or someone on his or her behalf who is aware of the case. Okay, these two people can file the writ under Article 32 for Supreme Court and under Article 226 for High Court. We have seen that. Now, the writ is not issued in these cases when the detention is lawful, when the detention is proved to be legal. In that case, you cannot issue the writ. Now, for example, there is a case of preventive detention. Okay, we all know when you detain a person as a preventive measure. That person has not done a crime, but he has been detained as a preventive measure. Now, if this detention is found to have a legal base, okay, then you cannot issue the writ of habeas corpus. If that detention is found to have a legal base, then you cannot issue the writ of habeas corpus. So it says that if the detention is lawful, you cannot issue the writ. Now, if the proceeding is for the contempt of legislature or a contempt of court, then you cannot issue the writ. And when the detention is by a competent court, that means when the court has the authority to detain, okay, and when that detention is by a court who has the authority to detain, in that case you cannot issue the writ of habeas corpus. And when the detention is outside the court's jurisdiction, that means that that detention is outside the area where the court can operate, okay, in that case you cannot issue the writ of habeas corpus. So this was about this. So in this we have understood that the writ of habeas corpus is granted by the courts to determine the reason for that person's imprisonment. Okay, the reason for the imprisonment, the reason to detain that person. So it therefore serves as a procedural shield against the law enforcement agencies who has the ability to detain. It serves as a procedural shield. Okay. So, based on our discussion, now you may try to attempt this question. I hope you got some clarity based on this concept. I will see you in the next video. Thank you.